Michael Popok with a Legal AF hot take as we await the opposition brief from the special counsel against Donald Trump and his efforts to overturn the D.C. Court of Appeals decision that he does not, nor any other occupant of the Oval Office, have absolute presidential immunity for acts while in office that are criminal after he leaves office. That appeal will be heard by the United States Supreme Court on the 25th of April. I've been able to really dive down into the briefing, and I'm going to tell you a number of things that are head scratchers, some of which that were also picked up by the Wall Street Journal. I'll combine the two right here on this hot take. Sit tight. First of all, when you're writing an appellate brief and you're appealing to the highest court of the land from a prior court, in this case, the D.C. Court of Appeals, one of the things that's incumbent upon you to do in your appellate briefing, here we got a breakout session of Legal AF Law School here. One of the things that it's incumbent upon you to do is to address the underlying decision, the ruling, the order of the court you're appealing from. I mean, the D.C. Court of Appeals and its three-judge panel, Pan, Henderson, and Childs, issued the per curiam decision. It's a 50, 60-page opus. It categorically and clinically goes through each of Donald Trump's proposed defenses and arguments, from structural separation of powers, immunity, supremacy clause, impeachment, conviction in the Senate has to come first argument, and everything else that he raised to argue for absolute immunity for official or unofficial acts. Anybody who occupies the presidency, according to Donald Trump, has the superpower that he can get away with it. He can literally get away with murder, or as Judge Pan put it during her cross-examination during oral argument of John Sauer, he can get away with ordering SEAL Team 6 to murder a political rival. Now, what I was looking for in the brief and is after the Supreme Court narrowed the appeal to one issue and one issue only. And that one issue is, can a former president use presidential immunity? Is he immune from criminal prosecution for official acts? That's all the Supreme Court wants to know. And sort of implicit in that, impregnant in that, if you will, is a couple of things that the Supreme Court is interested in. They're not interested in anything else that's in the decision by the District Court of Appeal, which should be a signal to the Trump organization or the Trump people, Trump lawyers like John Sauer, that they're in trouble. Because my working theory is the rest of the decision that they made about presidential immunity not applying to somebody, and that the acts that he's being accused of fall far outside presidential duties. Therefore, they're not official acts, and there has to be a checks and balance on a rogue, out-of-control president. The only way you can do that is by making him comply with Congress's laws in the forms of criminal laws, and allow the executive branch, Department of Justice, and prosecutors, and Article 3 judges of the judiciary branch to hold him accountable. That's our separation of powers. Laws passed by Congress, the executive branch, and the Department of Justice is the prosecutor, and the lawgiver is the Article 3 judge, right? And that's how you keep the Article 2 president in check. And so what you need to do when you file the brief, and I've done a fair amount of appellate work myself and argued at appellate levels, is that you have to explain to the Supreme Panel, in this case the Supreme Court, why the lower court was wrong. The lower court erred. The lower court made an error of law, an error of fact, applied the wrong standard, didn't apply the right case law, missed this line of precedent. They didn't do any of that. They barely, in fact, John Sauer's brief on behalf of Donald Trump barely mentions at all the order that they're appealing from. That is, they just think they get a whole new do-over. Like it's a giant legal constitutional etch-a-sketch, and they can just shake it and erase it, and they can just start all over again. That's not how appeals work. There is a certain amount, you have to show a certain amount of error, right? And you have to say what the standard of review is, which they didn't do, and then you have to analyze the case given the order that you got against you, and tell the new court, the highest court, the Supreme Court, why they were wrong. They just start all over again, as if there wasn't a District Court of Appeal decision, when there is. Okay. And the Supreme Court knows that there is. In fact, the Supreme Court I think, has adopted or will adopt the thinking and the analysis in that brief. They just want a couple of loose ends tied together, because I don't think this United States Supreme Court ever wants to touch the issue of presidential immunity ever again. I mean, about every 10 years, the Supreme Court, in some combination of justices, has to address presidential immunity. But when you have a indicted former rogue criminal president, there's a lot of cases that are going to come out of the Trump era. They're going to have Trump's name on it that are going to be cited in the future. Just as there were a lot of cases with Nixon's name on it during the last time we had a corrupt, out of control president that had to get impeached and then removed from office. And so that's the one peculiarity, I'll put it, of the brief: a complete failure to recognize the prior ruling or argue around it or against it on the proper standard. That's probably fatal to their argument. And second is, as the Wall Street Journal pointed out, this consistent habit of theirs of misciting case law and sending it in as their own. I'm sorry, I think I said Wall Street Journal. It's Washington Post. And in particular, they made a big deal in the brief of citing to and trying to gain the favor of one Brett Kavanaugh, who Donald Trump put on, and who Donald Trump, as Alina Habba, his lawyer, likes to remind Kavanaugh in a very unseemly way, in a very dirty-handed way in the press, that, you know, Trump had your back when you were being attacked for sexual assault in college, and, you know, when the Dr. Blasey came forward and attacked him at a confirmation hearing, series of hearings. He had your back then. You got his back now. I mean, that's not how that works, Alina. I know you think it's a quid pro quo in a trade and trying to extort a sitting United States Supreme Court justice, but that's not how it works. But they love Kavanaugh, and they love citing him and trying to ring his bell and get him to take the bait. And I guess that would be effective if they weren't misciting him in a law review article that he wrote years before he became a judge or a justice, in which he said the exact opposite of what they're arguing. In fact, plays right into the hands of the special counsel and the other side and the prosecution, that there is no absolute presidential immunity for a former president after he leaves office. The entire article that Kavanaugh wrote that they cite and they showcase in the brief is about a sitting president not being subjected because it will interfere with his ability to do his job. But implicit and actually expressed in the article by Kavanaugh, and I'm going to tell you the title in a minute of his article, is that once he leaves office, all bets are off. And that you can go after a former president, which is the exact point that's being raised by the question. I mean, for all we know, Brett Kavanaugh is the one that framed the question on appeal that they have to answer. They must have thought he was, but they've completely misread and misinterpreted, or as the Washington Post put it, in head-scratching fashion, they've completely turned upside down Kavanaugh's comment and attributed it to him. I'm going to tell you what I'm talking about here. So in Kavanaugh's article, or in their brief citing Kavanaugh's article, they cite to Kavanaugh this way. They say in their brief, in short, a president who is concerned about an ongoing criminal investigation is almost inevitably going to do a worse job as president. The same conclusion holds if the criminal investigation is waiting in the wings until he leaves office, except that's not what Kavanaugh said. In the note that was written and by Kavanaugh in his article, which I'll show you a picture of in a minute, Kavanaugh posited only that presidents shouldn't have to face criminal prosecution while in office. That's the very nature of the question that's been asked on appeal. A former president. Does a former president have that? Again, the more I say it out loud, the more I think Kavanaugh wrote the appellate question. And he said at the time, he answered his own question, and he said a sitting president shouldn't be subjected to criminal prosecution, right? But he took no position in the article about a post-presidential indictment. In fact, Kavanaugh is quoted in this article as saying, the point is not to put the president above the law or to eliminate checks on the president, but simply to defer litigation and investigation until the president is out of office. They left that out of their brief. Sort of like, I said this before, I used to build like model airplanes when I was a kid. And sometimes it was a very complicated model. And there'd be parts that I couldn't figure out because, I was like 6 or 7 years old, that where they went. And I just have like, the plane would look all right, I'd paint it. But there'd be like this pile of parts on the side that I couldn't like figure out how to put in. It's sort of like this. They didn't like that quote by Kavanaugh, but and so they didn't include it. But that's not being upfront and trustworthy. And that's not having the candor to the tribunal that you're required to do. And it's easily refuted by Kavanaugh, who's probably shaking his head and chuckling along with his other colleagues, like, that's not what I wrote. In fact, the title of the section in the article that they quote from is all in bolds and caps as follows: provides sitting presidents with a temporary deferral of civil suits and of criminal prosecutions and investigations. Temporary, meaning they don't enjoy it after they leave office, which is exactly the point that's being raised now and on appeal. So why? It's just completely gobsmackingly stupid. But it's just one example of the Trump people and John Sauer citing things inappropriately, wrong, upside down, misciting them, half-citing them, and then getting it handed back to them. Look for Kavanaugh on the 25th to remind Mr. Sauer that he completely misstated his position. Why? I mean, that would be the ultimate unforced error. You've got the Kavanaugh thing. You've read it. You might want to shape your argument to address something that a young Brett Kavanaugh, before he was a judge, might have believed. But don't say that he supported your position when he supported the exact opposite. And that's the very issue you're there for on appeal. I mean, we've seen this before, right? John Eastman used to file things on behalf of Donald Trump, where he took these ridiculous historical positions. Never in the history, whenever you see a Trump brief that says, never in the history of the United States has something happened, I assure you it has happened. They just haven't found it, or they misstate it to the tribunal. It's like their tell when they see it, when you read it, when you read that, just think to yourself, that's wrong. I'm sure there's a historical precedent that they haven't found, or they didn't want to find, or they buried, or whatever it is. But the Kavanaugh thing is completely gobsmackingly stupid, right? To say, as Justice Kavanaugh knows well from his own note, cite Brett Kavanaugh at. The note is against you. Sure, it's smart of you to address it because it's going to come up, but don't tell the author, who has a title that says temporary reprieve for a sitting president, but will handle it after he leaves office, in a case about a president who left office and is trying to use it now. So look, I think that Kavanaugh is not the friend indeed and the friend in need for Donald Trump that Donald Trump thinks he is. He has his views of presidential power that are not consistent with a run of mock Donald Trump. And fundamentally, as I've laid out here, their appeal has a big giant hole, like a glowing radioactive donut hole in the middle of the brief, where they don't bother to address the decision from below at the District Court of Appeals that obviously the Supreme Court gives a lot of merit and credit to. It's coming, first of all, it's coming up from the DC Court of Appeals, which is often considered to be sort of the tryout and the feeder program for the Supreme Court, because the justices there, the judges there often get elevated, right? Ketanji Brown Jackson came from there. Merrick Garland would have been on the Supreme Court, came from there. The list goes on, John Roberts and the like. So they already respect their colleagues on the DC Court of Appeals, among all other courts of appeal. So that's one. Two, you have an obligation under the appellate rules to properly lay out the argument. You can't just run your same argument as if you won below and when you lost, and not acknowledge the order from which you're appealing, and then don't analyze around it. And then answer questions that haven't been asked by the judges. They're back arguing the same failed arguments that were rejected by the DC Court of Appeals, and the Supreme Court didn't ask for argument on that. The Supreme Court doesn't want to hear argument on their position that there has to be a Senate conviction after a House impeachment of a president before, in later life, after he leaves office, he can be subject to criminal prosecution. That's a loser argument, both from the literal text of the Constitution and from historical precedent, it was roundly rejected by the D.C. Court of Appeals. And the Supreme Court doesn't want to hear about it because they didn't put it in the framing of their question, the sole question on appeal. Does a former president enjoy absolute presidential immunity for official acts? All they want to hear from the words of the lawyers are official acts, what constitutes it, a former president, back to the Kavanaugh point, and whether there's going to be a lack of checks and balance on a rogue, out of control leviathan of a president. Yes or no? Is that the country we're going to live in? So we'll continue to follow it. We'll get a new brief. I'm sure that'll be pointed out by Jack Smith and maybe by the Solicitor General, who will file a brief, hopefully on behalf of the United States government and take a position there as what's called the 10th Justice. I hope that happens. And we'll catch it up. When the audio of the oral argument is finally heard on the 25th of April, we'll get a copy of it and we'll do hot takes on it right here on Legal AF and on the MeidasTouch Network and on our show, Legal AF, on Wednesdays and Saturdays at 8 p.m. Eastern Time. We sit at that intersection of law, politics, and justice, so you don't have to, with lawyers who know what they're talking about at that intersection. How novel, how refreshing. If you like that kind of debate and discussion and analysis, you come to the right place. And then on our audio podcast platforms, you can pick up Legal AF. Yep, the name means exactly what you think. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.